Welcome to another edition of Question and Answer with a Criminal Defense Attorney. My name is Mark Solomon, a defense attorney in Denver, Colorado, and today's question is about complicity, sometimes known incorrectly as accessory before the fact. But before we get to that, don't forget to click subscribe with a little bell next to it to be notified of future videos I upload, plus click like on this video if you're enjoying it. Let's get to the question. So, complicity, accessory before the fact. That's a misnomer. Let me explain that. When you're being charged with being complicit in a crime, it means that you're going to be charged just like the person who committed it. Let's look at the statute on that one so that you can understand why I say that. I'm going to read this. A person is legally accountable as the principal for the behavior of another constituting a criminal offense if, with the intent to promote or facilitate the commission of the offense, he or she aids, abets, advises, or encourages the other person in planning or committing the offense. Here, I'll come back to that in a second. First off, I'm going to link to the video I did yesterday, which is the accessory after the fact. That's the true, the accurate that's the accurate place when you can say accessory. That's when you're helping somebody to avoid detection. See that video for a full description. We're talking about complicity, which, let's break this down a little bit. A person is legally accountable as the principal for the behavior of another. So in other words, if a person commits a bank robbery and you helped them get there and you knew that they were going to do a bank robbery, you're going to be charged with bank robbery, period. There's no difference in helping somebody before or during a crime. You're going to be just as legally chargeable. And that's for the behavior of another. If with the intent to promote or facilitate the commission of the crime, in other words, they have to prove that you intended to actually help this person, that you actually, and this is where the aiding and abetting comes from, you actually aid, abet, advise, or encourage the other person in committing the offense. So if a person comes to you and asks you the best way to rob a bank and you tell them and then they go off and rob a bank, that's probably something you could be charged with under the definition of complicity. So aiding and abetting is akin to the word complicity. Lawyers, judges, prosecutors, we all use the term complicity. We know what that means. But if you say you were aiding and abetting, that's the shorthand version of that. So if you help somebody before or during the commission of a crime, you'll be just as legally accountable as the person who committed it, that you aided and abetted or encouraged. On the other hand, if you help somebody after the fact, it's a slightly lesser charge. So that is the question and answer for today. If you would like your own question in future videos, don't forget you can email me, tag me on Twitter, or put them in the comments below. And as always, you have a right to remain silent. If a police officer asks you questions about what you have, where you've been, what you know, anything, you have a right to say, I don't want to talk to you. And if they persist, you can always ask for an attorney.